great debate. You can only claim refund and not damages. What do you say about this?
Much obliged, Your Lordship. That remedy was available to us only in case of delay, Your Lordship, but nothing in the contract is mentioned that what remedy we will avail if they breach the contract.
They are raising their concern that you must give us it with interest, which is a clear violation of the contractual agreement, and they are not ready to settle the dispute through negotiation, Your Lordship.
And secondly, Your Lordship, if his 30 lakhs was not stuck there, he may have the opportunity to invest it somewhere else from where he have earned a large amount of income, Your Lordship. That was all my submission, Your Lordship.
For subclass 2 of the contract agreement, Your Lordship, the buyer is legally capable of entering into contract and has sufficient financial capacity to fulfill this contract. It is explicitly mentioned before entering into the contract with NRC that I have sufficient financial capacity to fulfill the payment, and now only 13 months are passed and 13 installments are, they have to pay for 20 installments, Your Lordship. If he is not capable to fulfill the contract, the contractual agreement to fulfill the installment, then why he enter into the contract, Your Lordship?
Now we should pass a judgment.
Since this present suit pertains to breach of contract, refund of payment and compensation, all of which are civil matters and comes within the jurisdiction of this honorable court, Your Lordship, secondly and most importantly, in the contract between Ali Raza versus National Real Estate Corporation, the word may is used for arbitration, not shall. It means that civil court is not expressly barred from hearing this case. Your Lordship, in support of this stance, the council would like to present a case law which is reported as PLD 2016, Supreme Court, page number 121. Your Lordship, in this case law, the Honorable Supreme Court held that the intention of the parties to refer the matter to arbitration can be inferred from the language used in the document. Thirdly, Your Lordship, the nature of relief sought. The plaintiff is seeking injunctions and damages, etc., which goes beyond the scope of arbitration. Hence, this Honorable Civil Court has jurisdiction to entertain this suit. Your Lordship, there is another case law which are supporting the stance of plaintiff, which is reported as PLD 2014, Singh, page number 504. Your Lordship, in this case law, the Honorable Court rejected the application and held that, Your Lordship, I am seeking your attention to the last page of that reported judgment, the last page, Your Lordship. The Honorable Court held that sufficient reasons have been shown by the plaintiff for not referring the present matter to arbitration. The suit must be allowed to proceed and be heard on its own merit. The present application filed is hereby dismissed. Since, Your Lordship, in the present case, the counsel for the plaintiff already submitted that the relief which plaintiff is seeking, like injunction and damages, that is not coming within the scope of arbitration. So, Your Lordship, that's why this Honorable Civil Court must entertain this suit. Your Lordship, there is also another case law having title Pakistan International Airlines Corporation versus Mrs. Park Soft Dry Cleaners, reported as PLD 1981, Supreme Court, page number 553. This case law is also clearly supporting the stance of plaintiff. Your Lordship, in this case law, the Honorable Court held that the mere existence of arbitration clause in the contract does not bar a suit or other legal proceedings in a court. Your Lordship, if the Honorable Court is satisfied regarding the jurisdiction, may I proceed toward the second issue? Your Lordship, the issue number second framed by this Honorable Court is that whether the defendant Ali Raza committed a breach of contract or not. Your Lordship, the counsel on behalf of plaintiff respectfully submitted that yes, the National Real Estate Corporation committed a breach of contract by failing to obtain the necessary environmental clearances for Green Meadow Residency project. The council have 5 submissions in this regard, Your Lordship. Firstly, that how NREC committed breach of contract, which is the main cause of action. Your Lordship, if we look at clause 3, para 4 of the contract of sale between the parties. Your Lordship, clause 3, para number 4 of the contract of sale between the parties. This para states that the defendant is responsible to obtain all environmental clearances and other regulatory approvals within reasonable time. Your Lordship, despite passing of 12 months, NREC failed to obtain necessary environmental clearances, hence they clearly committed a breach of contract. Secondly, Your Lordship, also according to clause 3, para 5 of the contract between the parties, the defendant NREC was responsible that in case if government halt the project due to regulatory approvals or any other reason, the defendant NREC was bound to inform the plaintiff Ali Raza within 7 days through a written notice. Your Lordship, the point to be noted here is that they also failed to notify the buyer Ali Raza within 7 days through a written notice. Hence, they also breached this term of contract and committed a breach of contract. Your Lordship, my third submission in this regard would be the legal provisions which has been violated. Your Lordship, section 37 of Contract Act states that the parties to the contract must perform their respective promises. Failure of NREC to obtain regulatory approvals directly violates section 37 of Contract Act 1872. Your Lordship, secondly and most importantly, Section 19 of Islamabad Real Estate and Regulation and Development Act 2021 is also expressly violated by the defendant NREC. Your Lordship, Section 9, Subsection 1 of Islamabad Real Estate Regulation and Development Act bound the seller to inform the buyer about everything as agreed between them and the contract. Your Lordship, as I've already submitted that they failed to inform the buyer Ali Raza within 7 days, which was their duty according to the contract. So Your Lordship, this violation also violates Section 19 of Islamabad Real Estate Regulation and Development Act 2021. Thirdly, Your Lordship, they have also violated Section 46 of the Contract Act 1872, which states that where no time for performance is in the contract is specified, the contract must be performed within reasonable time. Your Lordship, the failure of NREC to obtain regulatory approvals within reasonable time also violates Section 46 of Contract Act 1872. Your Lordship.
So what would be the reasonable time here in the particular instance?
Much obliged. Your Lordship, the reasonable time in this case is 12 months. Your Lordship, they failed to obtain the regulatory approvals despite passing of 12 months. Your Lordship, the point to be noted here is that CDA issued notice to NREC on 1st February 2024. Your Lordship, CDA halted their construction on 1st February 2024, while they entered into contract with Ali Raza on 1st March 2023, Your Lordship. Your Lordship, 12 months has been passed since they failed to obtain regulatory approvals regarding environmental clearances from Environmental Protection Agency, Your Lordship, since they violated this term of contract. If the Honorable Court is satisfied regarding my submission regarding the breach of contract, may I proceed toward the issue number 3rd? Much obliged. Your Lordship, the issue number 3rd framed by this Honorable Court is that whether the plaintiff right as consumer has been violated or not. Your Lordship, I am seeking your attention to page number 21st of the memorial. Your Lordship, the counsel on behalf of plaintiff respectfully submits that the question of consumer right is secondary to the main cause of action, which is the breach of contract. The plaintiff has approached this Honorable Court not as a consumer but as a contracting party whose right has been violated by the defendant NREC as evident from the plaint, Your Lordship. The counsel has 2 submissions in this regard. Firstly, Your Lordship, the plaintiff is not claiming consumer right violation. Your Lordship, we are claiming breach of contract as evident from the plaint file, which clearly states that we are claiming a refund of payment, compensation, and injunction against further slot sale. Your Lordship, so my second submission in this regard would be the court has authority to make determination on consumer right violation. Your Lordship, although the plaintiff is not relying on consumer protection law and we are not claiming it under the plaintiff, under the plaint file, but yet, Your Lordship, this court has discretion to determine that along with breach of contract, our consumer right is also violated or not. And if this honorable court determines that our consumer right is also violated, then we will also have the opportunity to approach the consumer court against the defendant. Your Lordship, the plaintiff's stance is clear regarding this issue. We are not claiming consumer right violation, we are claiming breach of contract. That's why we approach this honorable civil court, not consumer court. Your Lordship, this does not affect the current breach of contract claim, nor does it require the case to be transferred to the consumer court, as we have not claimed it. We are only claiming the breach of contract. If the honorable court is satisfied regarding this issue, may I proceed toward the next issue? Much obliged. Your Lordship, the later three issues will be addressed by my co-counsel. Thank you, Your Lordship.
Can you tell me whether you have filed court fees, regular court fees in this judicial crime?
Yes, Your Lordship, we have filed.
How much?
Your Lordship, the fees, the submission of fees is not available on record, but this honorable
The value of the case property is 3 lakhs rupees,
30 lakhs rupees. Yes, Your
So how
Lordship.
much will be fined fee? How much court fee will be required to be filed?
Your Lordship, counsel is ignorant of the fact.
This is the very primary issue.
Yes, Your Lordship.
The plan can be rejected at the very initial stage when you have not filed the requisite court fees, because you must mention in the heading of the plan that I have filed this, the value of the purpose of court fees is this, and I have filed this thing. For this purpose, you have to consult the Suit Valuation Act, which says that at least 15,000 rupees court fees is required to be affixed with the plan. If this is not affixed, no degree will be done in your favor.
Much obliged.
Despite that, you have a very good case.
Much obliged. Your Lordship, as this honorable court has, as honorable court decided this case to be heard, the fees is already paid by the counsel, Your Lordship. Thank you, Your Lordship.
Thank you, Your Honor. With due permission of the court, may I proceed with the fourth issue? Your Honor, the fourth issue is whether the defendant can successfully invoke the force majeure clause to justify the delay in fulfilling its contractual obligation. Your Honor, no, the defendant cannot invoke the force majeure clause, and the defendant reliance on the force majeure clause is completely unjustified. Your Honor, I have several submissions regarding this clause. My first submission is related to clause 6 of the contract parcel, which contains the force majeure clause. Your Honor, it states that neither party shall be liable for failure or delay in performance under this contract due to circumstances beyond their control. Your Honor, in order to invoke this clause, it is a necessary condition that the circumstances must be beyond their control. Obtaining environmental clearances was not beyond the defendant control, and it was due to the negligence of the NREC, because, Your Honor, if we look at the text of the case, the defendant has submitted compliance report on 28 February 2023, and the CDA had issued notice on 1st February 2024. Your Honor, it has a gap of 11 months and 10 days. During this gap, the defendant has not addressed any query from the EPA, nor write any application to the EPA to obtain updates about the delay. Your Honor, it clearly shows the delay on the part of the defendant. Now coming towards the CDA notice. Your Honor, if we look at the CDA notice, CDA gives 30 days time to the defendant to do the compliance by getting the pending approvals of environmental clearance. Your Honor, the defendant did not do compliance within 30 days after receiving the CDA notice. So, Your Honor, it also clearly shows the negligence on the part of the dependent. Now, Your Honor, if we look at,
Please can tell me it is whose responsibility to clear the environmental issue? Whose responsibility to clear the environmental issue?
the dependent has the responsibility under the contract parcel, because it was stipulated under the contract parcel that they will obtain the environmental clearance under the reasonable time.
You are a defendant.
No, sir, I'm from the plaintiff side.
You are plaintiff side. You are from defendant side, not on plaintiff side.
I'm from the plaintiff side.
The second also.
Yes, Your Honor. I am addressing the remaining three issues. Your Honor, if we look at the date of the CDA notice, 1st February 2024, and my client has filed the suit on 1st May 2024. Your Honor, during these 2 months, there is nothing available on the file which shows that the dependent has done something about the CDA notice. So it also shows the negligence of the dependent. Your Honor, now coming towards the onus of proof. My second submission is regarding the onus of proof. Your Honor, it is a general principle of law and jurisprudence. Whoever takes the shelter of general exceptions like force majeure, the onus of proof shifts to the party who is claiming it. Now it is upon the dependent to show that they have acted in good faith and the circumstances were not beyond their control. So, Your Honor, while from the facts it is evident that the dependent failed to obtain the environmental clearance due to their negligence. Now, Your Honor, coming towards the case law, the counsel shall rely on the case law cited as Atlas Cable Private Limited versus Islamabad Electric Supply Company Limited, reported as Solar CLT, page 1833. Your Honor, in this case, the dependent has invoked the force majeure clause on the basis of international increase in prices. And the Honorable Court held that in this case, that the international increase in prices of particular material, which is metal in this case, is not sufficient to constitute a force majeure clause. So, Your Honor, according to this case law, the acts of government does not constitute the force majeure. Your Honor, if the Honorable Court is satisfied with the fourth issue, may I proceed towards the fifth issue? Much obliged, Your Honor. The fifth issue before this Honorable Court is that whether the plaintiff Ali Raza is entitled to claim damages beyond a refund of the amounts paid, including compensation for financial and personal losses allegedly suffered as a result of the dependent's breach. Your Honor, as already discussed by my co-counsels, that the dependent has explicitly breached the contract. So Your Honor, the plaintiff Ali Raza is entitled to claim damages beyond the refund of the amount claimed, including compensation for financial losses and personal losses. Your Honor, I have several submissions regarding this stance. My first submission is regarding the reasons for which I am claiming the compensation. Your Honor, due to the delay in possession, the plaintiff has been forced to continue paying rents for his residence. This dual burden of rents and flat installment is a direct financial loss caused due to the dependent's breach. Your Honor, the second reason, if the plaintiff has invested this amount in an alternative property or something where the plaintiff could have generated income from this investment. So, Your Honor, it also shows that we are entitled for the compensation. Third reason, Your Honor, the dependent's breach has caused the plaintiff litigation costs, including the court fee and the attorney fee. Now coming towards the fourth reason, the plaintiff has suffered emotional stress by managing both the house rent and installment fees. Your Honor, the plaintiff has also suffered emotional stress due to uncertainty about the project's completion. Your Honor, my second submission is related to the legal basis. According to Section 19 of the Specific Relief Act 1877, the court is empowered to grant compensation for the breach of contract. And Section 73 of the Contract Act 1872 establishes the right of an aggrieved party to claim damages for the losses caused by the breach. So, Your Honor, the plaintiff is claiming damages under Section 19 of the Specific Relief Act and Section 73 of the Contract Act 1872. Now coming towards the case laws. The court in this case held that damages for mental shock and torture fell in the category of general damages for assessment of which no dependent method was laid down. Primary consideration of court in such cases should be to compensate the plaintiff as far as possible for the injury caused to them. So, Your Honor, according to this case law, the compensation for damages caused by mental torture need not to be proved. If the Honorable Court is satisfied with my submission in the 5th issue, may I proceed with the 6th issue?
Okay, can you point out any?
Much obliged. Your Honor, the first issue framed by this Honorable Court, the Civil Court has got the jurisdiction to entertain the suit. So, Your Lordship, my first submission before this Honorable Court is no, the Civil Court has got no jurisdiction to entertain this suit. Because, Your Lordship, I want to draw the attention of this Honorable Court to page number 7 of the Moot Petition. Your Honor, page number 7 of the Moot problem. Your Lordship, if we look at the clause number 8, para number 1 of the Moot preposition, it categorically says that, Your Lordship, it categorically says that in the event of a dispute arise out of or in connection with this contract, the parties agrees to attempt resolution through negotiation. Your Lordship, point to be noted here. My Lord, here the plaintiff,
Page number?
Your Lordship, page number 7 of the Moot preposition, clause number 8, para number 1, which categorically says that, Your Lordship, in the event of a dispute arising out of or in connection with this contract, the parties agrees to attempt resolution through negotiation. Here, point to be noted, Your Honor, the plaintiff Ali Raza has completely overlooked, and I can say that plaintiff Ali Raza has violated the contractual obligation on which he has willingly signed this contract. That an event arising, that a dispute arises, we will consult this, we will resolve this through negotiation. But instead of negotiation, Your Lordship, he directly approached the civil court, which is not the proper forum to entertain this suit, because the plaintiff Ali Raza should solve this matter through negotiation. Furthermore, Your Lordship, if we look at the para number 2 of the clause 8, that categorically says that if a resolution is not achieved within 30 days, either party may refer the dispute to arbitration under the Arbitration Act 1940. I want to draw the attention of the Honorable Court here. Point to be noted, my Lord, here they have completely violated the second option. After the negotiation, he should do that, he should try the arbitration. But again, for the second time, he has completely violated his contractual obligation and directly filed the suit in the Islamabad Civil Court. That is why, my Lordship, it is my humble submission before this respectable court that this Honorable Court, that the plaintiff should resolve this matter through negotiation and the arbitration. That is why the civil court has got no jurisdiction to entertain this suit. Your Lordship, clause number 5 of the contract categorically says that in the case of regulatory delays exceeding 12 months, the clause 5 of the contract, while the plaintiff is claiming the refund with interest, Your Lord, my Lordship, point to be noted here, the plaintiff is claiming the refund of payment with interest, which shows that they are completely violating the terms and conditions of the contract. Your Lordship, this contract, my last submission regarding this issue before this respectable court is that the contract is still ongoing, and we are not denying the position of the plaintiff. First, the plaintiff should fulfill their contractual obligation, and your Lord.
Does it also have regard to the provision of Section 12 of the Pakistan Environment Protection Act 1997? It says that the compliance with this requirement is mandatory before initiating any development, construction or project of the sale. What do you say? Have you violated section 12?
No, Your Lordship. Your Lordship, when the defendant was signing the contract with the National Real Estate Corporation, there was categorically mentioned in that contract that the time period for the plot will be 24 months. We are still here. We will give the plot within 24 months to the.
It means that counsel, you are ready to get the required certificate from the concerned department.
Of course, Your Lordship. We are trying a lot, and we are trying a lot, and we have still we have 24 months, which is a lot of time, and we will complete the plot of the buyer and the Aliraza and other.
But as per the section 12, it was mandatory before initiating any constructions. You compliance with this requirement is mandatory before initiating any development construction. You started your development construction before complying this mandatory provision.
Answer to your question, Your Lordship. On January 1st, 2023, the Environmental Protection Agency has issued provisional environmental clearances to the National Real Estate Corporation, and after that, we continue our work again, and the National Real Estate Corporation is trying to complete the plot within 24 months. As we have signed the contract, we are still with the contract, and we have not reached the contract. 24 months are available. The reasonable time frame is 24 months, and we will complete the plot within 24 months. Your Lordship, they have completely, first they had agreed with us for the negotiation if a dispute arises, and then they violated again, and the second, the negotiation to arbitration, but he didn't consult with the National Real Estate Corporation and directly filed the suit with the Islamabad Civil Court in the Islamabad Civil Court.
Okay, Learned Counsel, you have said there is a arbitration clause in the agreement, but there is no mentioning that how this will be arbitrated, will be appointed. There is no black and white in the procedure of the appointment of arbitration agreement. In which case, what will we do? When there is no procedure provided in the agreement.
No, Your Lordship, there is mentioned that the Islamabad Civil Court will appoint the arbitrators to resolve the issue.
Which clause you will say?
May I take a moment before responding? May I take a moment before responding?
Okay, please.
With due permission of this honorable court, may I address this?
Please. No. We agree that there is an arbitration clause in the agreement, but this said that any party may, you may approach to the arbitrator instead of plaintiff. You may also approach to the arbitrator. Yeah, you may file petition under section 20 of the Arbitration Act before the Court of Civil. Okay, in this case, tell them the proceeding of the civil court may be stayed, and then proceed with the arbitration case.
In the once you said that there was a condition in the contract that the mutual dispute that could be resolved through negotiation.
Yes,
that was a condition.
Yes,
So tell me that if a mutual agreement can bar the jurisdiction of the civil court.
Your Lordship, according to the contract 1872, the plaintiff was bound to for the negotiation.
No, he was bound. But my question is that mutual contract, mutual agreement conditions in the contract can bar the jurisdiction of the civil court. For example,
Whether the party can settle the conferred jurisdiction upon a court with their mutual consent.
Your Lordship, that is mentioned in the contract. So then why the civil court has got?
You must refer to the Arbitration
Yes.
Act. You must refer to
Answer
the
to it.
Arbitration Act. It is categorically mentioned that when there is an arbitration clause, the party may file a petition under section 20 of the Arbitration Act before the Court of Senior Civil Judge, to the fact that the matter be referred to the arbitrator.
Yes.
Okay. Let's continue.
You people also have an option. Either party may to your contract, arbitration clause से उसमें either party can refer the matter to
जी सर.
आपके लिए भी ओपन है.
सर आंसर टू योर क्वेश्चन सर, क्योंकि हमारे पास 24 महीने थे, उस 24 महीने में हम उसको प्लॉट डिलीवर करने वाले थे. कॉज ऑफ एक्शन हमें एराइज नहीं हुआ सर. कॉज ऑफ एक्शन उनको एराइज हम तो अपने जो ऑब्लिगेशंस थे वो फुलफिल कर रहे थे, और इस हवाले से वो डायरेक्टली विदाउट इन्फॉर्मिंग अस योर ऑनर, विदाउट इन्फॉर्मिंग अस दे फाइल्ड अ सूट इन इस्लामाबाद सिविल कोर्ट.
आप जानिए ना उनके आपको तो काउंटर ब्लास्ट और आपको arbitration भी ये either party में जैसे arbitration के लिए तो
आप चले जाए
आपके लिए भी ओपन है.
और हम इस पे स्टे की एप्लीकेशन फाइल कर दें कि जी मान लीजिए एडवोकेट ने फाइल की है, आप एक एप्लीकेशन फॉर रिजेक्शन ऑफ रेंट के लिए फाइल कर दें. हैव यू फाइल्ड दिस एप्लीकेशन व्हेन यू आर इन इनिशियल स्टेट? इज द फाइनल आर्गुमेंट्स. ओके, प्लीज कंटिन्यू. जी प्लीज.
With the permission of this honorable court, may I proceed for a second? Please. Your Lordship, the issue number second raised by this honorable court is whether the defendant NREC committed a breach of contract by failing to obtain the required environmental clearances, thereby acting negligently. Your Lordship, my first submission before this honorable court is the defendant NREC regulatory clearances. Your Lordship, my first submission before this honorable court is that the defendant NREC didn't fail in complying with the required environmental clearances. Your Lordship, the NREC submitted their re-compliance report to the Environmental Protection Agency on 20 February 2024, while the CDA issued a notice to the NREC for halting construction on 1st February 2024. Your Lordship, there is a considerable gap of 11 months and 10 days. Despite passing of almost 1 year, the EPA did not issue environmental clearance, which was a bureaucratic delay and beyond the control of NREC. Your Lordship, the Council would like to draw the attention of this honorable court to clause 3, subclause 3 of the contract agreement, which clearly state that all requisites approval from governmental authorities for the sale and development of the project have been applied for, but certain clearances, including environmental clearances, are still pending as of the contract signing date. Your Lordship, it is categorically and explicitly mentioned in clause 3, subclause 3 of the contract agreement that all requisites approval are still pending as of the contract signing date. Your Lordship, the contract was signed between the plaintiff and Ali Raza on 1st March 2023. Your Lordship, the provisional environmental clearance to the NREC was granted on 1st January 2023. Your Lordship, the NREC acted diligently and with reasonable care by granting of the provisional environmental clearance under Section Environmental Protection Act 1997. Your Lordship, as the contract was signed between plaintiff Ali Raza and defendant on 1st March 2023. Your Lordship, the required regulatory approvals under Section 12 of Pakistan Environmental Protection Act 1997 was fulfilled by the defendant NREC. Your Lordship, the facts was misconstrued by the respected learned counsel for the plaintiff. Your Lordship, Class 4, Subclass 1 of the,
along with other affected buyers, repeatedly request update from NREC regarding the delay, but they simply answered that it is beyond our control and we cannot do anything about it. Secondly, your lordship,
It was just an inquiry about the environmental clearance. It can't be said that it was a formal negotiation.
much obliged, your lordship, but it is somehow showing that we have attempted to approach him and resolve the matter through negotiation. Secondly, your lordship, the counsel for defendant also misperceived the facts. They state that in the contract, it is mentioned that Islamabad Civil Court will appoint the arbitrator. Your lordship, nothing such is mentioned in the contract. And if they are claiming this, they can produce it before the Honorable Court. It is not mentioned, your lordship. In the file, your lordship, nothing such is mentioned in the contract. Your lordship, secondly, they are claiming that regulatory delays are beyond our control. Your lordship, clear proofs are available that they are not beyond their control. Your lordship, I am seeking your attention to page number 17 of the Moot
So
Court.
you mean that the environmental clearance certificate was to be obtained not by another department?
Your lordship, NREC was responsible to obtain environmental clearances, but they commit negligence.
From other department?
No, your lordship, from Environmental Protection Agency, but they have committed negligence. Your lordship, the proof of their
What
negligence
negligence they have?
is clearly available. Your lordship, the first negligence which they have committed is that they have submitted their compliance report to Environmental Protection Agency on 20 February 2023. Your lordship, 20 February 2023, while the CDA issued notice to them about halting construction on 1st February 2024, your lordship. There is a gap of 11 months and 10 days, your lordship. They were bound to approach the Environmental Protection Agency and inquire from them that why, despite passing 11 months, we have not granted the environmental clearances. Second proof of their negligence, your lordship, it is also available. Your lordship, from the CDA notice on page number 20, your lordship, they require the defendant NREC to reply to that notice within 30 days. They did not reply. Thirdly, your lordship, on page number 15,
Was it mandatory for them to reply to the notice?
yes, your lordship, it was mandatory. It was expressly mentioned by CDA in their notice. Thirdly, your lordship, a proof of their negligence.
Have you arrayed NRC as a party, NREC as a party to the suit?
Yes, your lordship, NREC is defendant in this suit.
No, sir. Environmental clearance.
Environmental Protection Agency.
Your lordship, much obliged. Your lordship, we have not made the Environmental Protection Agency as a party. Your lordship, our contract is with NREC. They are responsible to obtain environmental clearances. Your lordship, there is another proof available of their negligence. Your lordship, I am seeking your attention to page number 17 of the Moot problem. Your lordship, page number 17. Sorry, your lordship, page number 15. Page number 15, class 2, para 3. Your lordship, page number 15, class 2, para 3. EPA required them to submit air quality management report every quarter during the construction. It was their duty to submit the air quality management report. That's why the Environmental Protection Agency has not granted them the approvals, your lordship. It is clearly proving their negligence, your lordship.
Okay, Leonard Kozik, as per class 2 of the agreement, in case of any regulatory delay, you can only claim refund and not damages. What do you say about this?
Much obliged, your lordship. That remedy was available to us only in case of delay, your lordship, but nothing in the contract is mentioned that what remedy we will avail if they breach the contract. Your lordship, they have broken the contract. That's why we are claiming damages. And the reason for damages, your lordship, my client Ali Raza, he was a middle class citizen. Your lordship, 30 lakhs was a very huge. That's why his 30 lakhs was stuck in an unregistered project. That's why he has suffered mental anguish. And secondly, your lordship, if his 30 lakhs was not stuck there, he may have the opportunity to invest it somewhere else from where he have earned a lot amount of income, Your Lordship. That was all my submission, Your Lordship. Much obliged.
The counsel for the defendant seek permission from this honorable court to proceed with their answers.
Okay, conclude your argument in 2 minutes.
Okay, my lord. My lord, regarding the negotiation, the respected learned counsel raised the questions, raised the queries that we have tried for negotiation, Your Lordship. They have tried for negotiation and we also have tried for negotiation. We are ready to refund the amount in question which is paid by the plaintiff, which is the amount in question is rupees 30 lakh without interest, Your Lordship. But they are raising their concern that you must give us it with interest, which is a clear violation of the contractual agreement, and they are not ready to settle the dispute through negotiation, Your Lordship. Regarding question number 3, that there was negligence on the part of the defendant NREC, Your Lordship. There was no negligence on the part of the defendant NREC, Your Lordship. The counsel would like to draw the attention of this honorable court to class 6 of contract agreement, Your Lordship. Class 6 of the contract agreement provides insertion of force majeure clause, which clearly mentioned that neither party shall be liable for failure or delay in performance under this contract beyond circumstances beyond their control, including but not limited to act of God, governmental restriction, regulatory delays, or delay in receiving environmental or other governmental approval. Your Lordship, this is a case, the permanent environmental clearance is a bureaucratic delay and it is covered under force majeure clause, and the plaintiff has signed the agreement. Furthermore, Your Lordship, the counsel for the defendant shall rely on a case law, that is Abdul Wahid versus additional district judge and other, in which the honorable High Court further elaborated the term force majeure, that it not only cover the act of God but also including act of people, Your Lordship. Furthermore, Your Lordship, the force majeure clause, although not expressly provided under the contract agreement, but Your Lordship, in the said judgment, the Honorable High Court interpreted that under section 32 and 56, any party may rely upon the force majeure clause, Your Lordship. Your Lordship, the third question regarding they didn't. Your Lordship, their third question regarding their full environmental clearance, they didn't answer to the CDA notice within 30 days, Your Lordship. Under section 12, class 4, it is clearly mentioned that if after initial environmental impact assessment, the agency didn't communicate with the company, it shall be deemed to be approval of full environmental clearance within 4 months. Sorry, as the 11 months and 10 days have passed, so Your Lordship, it means that full environmental clearance is achieved. Your Lordship, their fourth concern is regarding breach of contract. Your Lordship, there is no breach of contract, and they are again the respected learned counsel argued that we are claiming for rental expenses too, as my client is a middle class person, Your Lordship. Class 4, the council would like to draw the attention of this Honorable Civil Court of Islamabad to class 4, subclass 2 of the contract agreement. Your Lordship, the buyer is legally capable of entering into contract and has sufficient financial capacity to fulfill this payment. It is explicitly mentioned before entering into the contract with NRC that I have sufficient financial capacity to fulfill the payment, and now only 13 months are passed and 13 installments are, they have to pay for 20 installments, Your Lordship. If he is not capable to fulfill the contractual agreement to fulfill the installment, then why he entered into the contract, Your Lordship? Your Lordship, the fifth question raised by the learned counsel is quarterly visit, that they will submit their quarterly visit report of the environmental impact assessment, Your Lordship. The quarterly visit is on behalf of the is on the part, it is the duty of the Environmental Protection Agency. They should quarterly visit the site of NREC, your lordship. And we also submitted the recompliance report within the stipulated timeline, as already argued before this honorable court. They required us to submit the recompliance report within 30 days, and we submitted it within 25 days, your lordship. This all.
Now we should pass the judgment.
जजमेंट आप मार्किंग करनी है सर
You went, where are both these teams? They are from law school.
Gujarat school.